introduction to property, and a quick doctrine reviewer for Articles 414 to 418 of the Civil Code. So property is a course in law and that branch of civil law which classifies and defines the different kinds of appropriable objects, provides for their acquisition and loss, and in general treats of the nature and consequences of real rights. So what is property? Property defined is an object which is or may be appropriated. It is synonymous with thing in discussions. It is submitted that the thing has a wider application as a term because thing includes both appropriable and non-appropriable objects, whereas property as a term is limited only to appropriable objects or objects that are susceptible to appropriation. So property involves not only material objects, but also intangible things like rights or credits. So classifications of property. First, there is the classification of things. There are three kinds of things depending on the nature of their ownership. One, we have res nullius, or things that belong to no one. Two, there's res communis, or things that are belonging to everyone. And three, res aliquotus, or that which belongs to someone specific. Res nullius contemplates things that have not yet been appropriated, or things that have been abandoned by their owner with the intention of no longer owning them. For res communis, these are things that are owned by everybody in that their use and enjoyment are given to all. And for res aliquotus, these are tangible or intangible things which are owned privately, either in a collective or individual capacity. So now we go to the classifications of property. There are several classifications. However, the most significant classification is based on mobility and immobility, which is provided for under Article 414. This article states that all things which are or may be the object of appropriation are considered as either immovable or real property, or movable or personal property. The human body, it has been submitted, is, whether alive or dead, neither real nor personal property, for it is not even property at all, in that it generally cannot be appropriated. So, it's a thing. It's not property. It is tangible, corporeal, but it is not property as it cannot be appropriated. So, immovable property. There are 10 kinds of immovables enumerated under Article 415. These will be discussed individually, but to quickly enumerate them. Number 1, land, buildings, and roads and constructions of all kinds adhere to the soil. 2, trees, plants, and growing fruits while they are still attached to the land or form an integral part of an immovable. 3, everything attached to an immovable in a fixed manner in such a way that it cannot be separated from the immovable without breaking the material or deterioration of the object. 4, statues, reliefs, paintings, or other objects for use or ornamentation placed in buildings or on land by the owner of the immovables in such a manner that it reveals the intention to attach them permanently to the tenements. 5, machines, receptacles, instruments, or other implements intended by the owner of the tenement for an industry or works which may be carried on in a building or a piece of land and which stand directly to meet the needs of the said industry or works. 6, animal houses, pigeon houses, beehives, fish ponds, breeding places of a similar nature, in case their owner has placed them or preserves them with the intention to have them permanently attached to the land, and thus forming a permanent part of it. This includes animals in those places. 7, fertilizer actually used on a piece of land. 8, mines, squares, and slag dams, which the matter thereof forms part of the bed, and waters either running or stagnant. 9, docks and structures, which though floating are intended by their nature and object to remain at a fixed place on a river, lake, or coast. And then lastly, contracts for public works and servitudes and other real rights over immovable property. So the law does not necessarily define what an immovable is. It only enumerates them under Article 415. So the first on the list is lands, buildings, roads, and constructions of all kinds adhere to the soil. This is the best example of an immovable property, as you can't move land, buildings, roads, and constructions. Even if a building was moved by an earthquake, then it would not be immovable anymore because it is no longer adhered to the soil. Buildings are considered immovable provided they are more or less of a permanent structure and substantially adhere to the land, not merely by superimpositions on the land. So this is true whether the building is built on one's own land or on rented land. However, a dismantled house or material subsets of the house should be regarded as personal properties or movable properties because they are no longer adhered to the soil. A house or building adhered to the land is a proper subject of a real estate mortgage. However, a house or building can still be the subject of a chattel mortgage in some cases, provided that two conditions are present: one, that the parties to the contract so agree, and two, no innocent third party is prejudiced. However, even if so stipulated by the parties to be personal property, still for purposes of sale at public auction, the house will be considered as real property. So what about constructions of all kinds adhered to the soil? It is understood that the attachment must be more or less of a permanent nature. So roads, railroad tracks, and rails are constructions adhered to the soil. So the second enumeration of immovables are trees, plants, and growing fruits while they are attached to the land or form an integral part of an immovable. Trees, plants, and growing fruits are always immovable so long as they are attached to the land, but the moment they are detached or uprooted from the land, they become personal property. So an exception to this is uprooted timber while it is in the timberland, because even if the timber has been uprooted, they are still considered immovable if they are in the timberland. So growing crops, whether on one's land or on another's land, is considered immovable. However, under the chattel mortgage law, growing crops may be considered as personal property and may thus be subject of a chattel mortgage. The third in the enumeration of immovables is everything attached to an immovable in a fixed manner in such a way that it cannot be separated there without breaking the material or deterioration of the object. An example of this would be air conditioning, like installed air conditioning units. They're attached in a way that the character is quite permanent. So fire escapes is well firmly embedded into the walls of the house, which cannot be removed without causing substantial damage to the house, in which case the fire escape stairway may be considered an immovable property. Fourth in the enumeration are statues, reliefs, or paintings or other objects for use or ornamentation placed in buildings or on lands by the owner of the immovable in such a manner that it reveals the intention to attach them permanently to the tenements. Under this classification here now, the statues, reliefs, paintings, or other objects for use or ornamentation are considered real property by incorporation and destination. They must have been placed by the owner or his agent, and it may be express or implied that they were placed there for the purpose of being of a permanent character. It is okay if they can be separated from the immovable without breaking or deteriorating. That's not necessary here. But the objects must be placed by the owner of the immovable or the land or the building and not necessarily by the owner of the object that was placed. Now, of course, the owner of the building or land may act through his agent, or if he is insane or incapacitated, through his duly appointed guardian. So for this, just remember it has to be the owner and there has to be intent to attach. Next is machinery, receptacles, instruments, or implements intended by the owner of the tenement for an industry or works which may be carried on in a building or a piece of land, and which stand directly to meet the needs of said industry or works. So the essential requisites under this article are the following: that the placement must have been made by the owner of the tenement or his agent or the duly authorized legal representative. 2. That the industry or works must be carried on in the building or the land. 3. The machines must stand directly to meet the needs of said industry or works. And for the machines, they must be essential and principal elements in the industry and not merely incidental. If the machine is still in the building but is no longer being used for the industry conducted in the building, the machine reverts to the condition of personal property. On the other hand, if it is still needed for the industry but separated from the tenement temporarily, the property continues to be immovable. So, as a general rule, machinery, receptacles, instruments, or implements are considered immovable when they comply with the requirements of paragraph 5 of Article 415. The exception here is when they are placed on the land or tenement by a tenant on the land. In that case, these machines, receptacles, instruments, or implements are then treated as movable or personal property. The exception to the exception is when the tenant had promised to leave the machinery to the owner of the tenement at the end of the lease, or when he only acted as agent to the owner of the land, in which case these are considered as immovable. Number 6, the enumeration of immovables continues to state animal houses, pigeon houses, beehives, fish ponds, or breeding places of similar nature. So, in case the owner has placed them or preserves them with the intention to have them permanently attached to the land and forming a permanent part of it, animals in these places are included. Even if the animals are temporarily outside, they may still be considered as real property so long as the intent to return is present. So, as in the case of, say, a homing pigeon. Okay, number 7. Fertilizer actually used on a piece of land. Fertilizer is considered immovable only if it has actually been used or spread over the land, because before that it is only movable. Number 8. Mines, quarries, and slag dumps. 9 is the docks and structures which, are, though floating, are intended by their nature and object to remain in a fixed place on a river, lake, or coast. So a floating house tied to a dock is considered real property, while vessels are considered personal property because they are indeed very movable, and because they are personal property, they may be subject to a chattel mortgage. So finally, our contracts for public works, servitude, and other real rights over immovable properties. So the properties referred to in paragraph 10 are not material things, but these are rights which are necessarily intangible. So the piece of paper on which the contract for public works has been written is necessarily personal property. However, the contract itself, or rather the right created by the contract, is the real property. A servitude or easement is an encumbrance imposed upon an immovable for the benefit of another immovable belonging to another owner, or for the benefit of a person, group of persons, or a community. Other real rights over real property include real mortgage, antichresis, possessory, retention, usufruct. The list goes on. Moving now to Article 416, which states the following things are deemed to be personal property or movable property. 1. Those movables susceptible to appropriation, which are not included in the preceding article, and 2. Real property, which by any special provision of law is considered personality. 3. Forces of nature which are brought under control by science, and 4, in general, all things which can be transported from place to place without impairment on the real property to which they are fixed. So the following are the tests to determine whether property is movable or immovable, and this is according to the commentary of Manresa. 1. If the property is capable of being carried from place to place. 2. If such change in location can be made without injuring the real property, to which, in the meantime, it is attached. And 3. If, finally, the object is not one of those enumerated or included in Article 415. In that case, the property is movable or personal property. Article 417 states that the following are also considered personal property. 1. Obligations and actions which have for their object movables or demandable sums, and the share of stock of agricultural, commercial, and industrial entities, although they may have real estate. Article 418. Movable properties, either consumable or non-consumable. To the first class belong those movables which cannot be used in a manner appropriate to their nature without their being consumed, and to the second class belong all others. So movable properties are then classified according to their nature or according to the intention of the parties. According to the nature, movable properties are consumable or non-consumable, and according to the intention of the parties, movable properties can be fungible or non-fungible. A movable property is consumable if it cannot be consumed according to its nature without its being consumed. It cannot be used according to its nature without its being consumed. So rice, food, whereas non-consumable is any other movable that is not consumable as to whether an so by the intended intention of the parties, a non-fungible or fungible movable property. The test is if it is agreed that the equivalent may be returned, then the property is fungible. So if you borrow something that can be replaced, like you borrow again rice and you replace rice, that's fine because it's equivalent of the same quality. The property is not only consumable, it is fungible. However, if it is agreed that the identical thing be returned, then it is non-fungible, even though by nature it is consumable. You got to give back those exact grains of rice. So that is property in general, Articles 414 to 418.